Hi, my name is Morgan Lyndall, and I'm an attorney at the Butler Law Firm. Today, I'm here to talk to you about what mediation is and what to expect when going to mediation. So, first and foremost, mediation is what's called a form of alternative dispute resolution. That's basically just a fancy way of saying resolving the case outside of the courtroom. So, is it arbitration? No, it is not arbitration. Mediation and arbitration are two different things, and the main difference is that arbitration is binding. Mediation is not. Mediation is a voluntary process, and you can choose to accept a settlement, make a settlement offer, or you can choose to walk away. So arbitration and mediation are two different things, and you should not get confused by that. All right, so let's get to what mediation is and what to expect when you go into it. So mediation is basically a meeting between the parties facilitated by a neutral or a mediator. And that mediator will run the meeting. And typically at the beginning of mediation, each party will give opening statements, and it's basically each party's position on the case. The plaintiff typically goes first, followed by the defendant, and if there's multiple defendants, oftentimes you'll have multiple defendants present. After those opening statements, the mediator will sometimes ask questions and then send you off to your caucuses or private meeting rooms. And what that is each party will meet in a different room so that they can discuss the pros and cons of a settlement offer that's given to them or a counteroffer to give back. And the mediator will move between each party to try to facilitate a settlement. So this can last hours, this can last days, depending on the case. Sometimes this can last minutes. I've been in a mediation where we sat down, we had some very strong terms that needed to be in the settlement, and the defendant said no, we will not do that, and it was over in about 22 minutes. So sometimes a mediation can be pretty quick. But just so you know, there is no settlement requirement. So you can go to mediation with an open mind and an open heart, but if you don't get the offer that you're expecting or something that you feel is good enough for you to compensate you for your injuries or your case, you can decline the offer. That's completely fine. But why am I there then? Well, sometimes courts require mediation before trial. And that 22-minute mediation I discussed with you, that was a case where the court, before allowing us to go to trial, required us to have a mediation to attempt to resolve the issues, even though in that case it did not appear that the defendant wanted to resolve the issues. Other cases, it can be a lot more successful even if it's not required by the court. You can voluntarily go to mediation if you feel like maybe a neutral would have the ability to help you facilitate that settlement. So I hope today we've helped you understand what mediation is and what to expect when you're there. If you have any issues or any questions, give us a call at the Butler Law Firm. We're happy to help.